matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to help you with the law matters because the law matters. We hope it educates, informs, and helps you. The law matters, understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources to help you decide whether you need or want to contact a lawyer. Perhaps we'll help you to determine that you might be able to handle some issues yourself. If you do need additional professional counsel, you'll be better prepared, and so will the professional who you choose. Either way, our goal is to help you save time, money, and achieve the best possible results. We welcome and thank Attorney David Bazar once again from the Bazar and Associates Law Firm in East Providence. They continue to provide us their legal insights, information on each of the topics that we select. So last session we discussed property ownership, particularly the pros and cons of joint ownership alternatives. Today, real estate, what you need to know and how to avoid problems when you're purchasing or selling a home. What should you do before you invest or you sell? What can you do when you discover that there are problems, even after the closing? So we'll go through a tutorial of title search, insurance, easements, escrows, a few of the frequently asked questions, the do's and don'ts, and a few examples in the real world that might help you prevent some unnecessary headaches. So let's begin with, since so much is available on the internet, David, if you're purchasing or selling a home, is it really possible that you can get away unscathed if you decide not to hire an attorney?
I wouldn't do that. So first of all, is there going to be a broker involved? And are we buying or selling?
Either way.
Okay. So are you borrowing money or are you paying cash? All of those things are factors that will play into it. If you are borrowing money to buy a home, the bank is going to require that an attorney be involved to do a title search and to do the closing and make sure all of the I's are dotted and the T's are crossed. And in real estate, that's really, really important. And they're going to require the attorney to do a title search, which is really, really important. So there is, in my opinion, almost no way under any circumstances that a person can and should do that on their own. As an attorney, I wouldn't even do it on my own without hiring another attorney who's more versed in title searches and all of those types of things than I am. And I do a lot of real estate work on my practice, but I know what I can do and what I can't do. And title searches are not something that I do. Title insurance is not something that I write, which is required with a bank loan and really recommended without one. So I would hire an attorney myself. I would recommend anybody buying especially, and really selling, to have an attorney represent them.
Good to know. So we should do a little drill down on that. But honestly, as in preparing for this, there are so many sources, even from Wikipedia and search queues, title search. There is a little bit more than a little lure to think that lure you into thinking you could do it on your own. But of course, if you're conservative or even thinking about the money involved, which usually means quite a bit on both sides, as you indicated, probably makes sense, especially if you're saying that you would do it yourself.
For most people, buying a home, owning a home is one of the biggest investments that they're ever going to make.
Yes.
It's one of their largest assets that they're ever going to own. And not to have the protection of making sure it's done right. There are so many issues that can go into that. And we talked about the title and make sure the title is correct. You talk about easements and whether there are any easements on the property, whether there are any liens on the property. All of these things play into it. And I just couldn't imagine spending the kind of money that we spend on real estate today and not making sure I have all the protection I can have.
So a question comes up in the basic FAQs, and I would take this for granted. Is the seller required to provide good marketable title? What does that actually mean? And isn't that a foregone conclusion? What does that mean?
There are a lot of different deeds that can be signed, which transfer title, And the marketable title that we're talking about here is a title that a bank, for example, would give a mortgage on and a loan for because it's insurable. So that covers a lot of different issues as to what marketable title is and or insurable title. And it involves, does the person who's transferring the property own the property? Are there liens, easements, or other defects in the title or encumbrances on the property? And when the property is transferred to me, if I'm not borrowing money, am I getting the actual outright ownership? So, for example, we talked before about someone who transfers the future interest to their home to their children and retains the life estate. So if I buy that property from that person and there's no mortgage on the property, there are no liens on the property, and they deed their interest to me, do I own the property? Well, actually, I only own what they owned, which is the life interest, which means I own it for as long as they're alive. So I may or may not want to buy the property for those purposes, but I'm certainly not going to be able to get a mortgage to buy it, and I'm not going to own it after they die. So is that really something I want to buy?
Sounds like that would be a reason for a lawsuit if someone presented it as you have it free and clear, when in fact that certainly has a lot of caveats and loopholes to it. So,
but people don't always understand that. And so they don't understand what they own and what they're transferring. And if you're doing it without an attorney, you don't really know what you're buying.
So when people talk about title examination or the thing called an abstract, what are those?
Title abstract. So a title examination is performed to create a title abstract, which is the chain of sort of title, the history of the title, and it gives you the information that you need to be able to buy the property, which is what we just talked about, really, which is who owns it, what do they own, and what liens or encumbrances are on the property.
So when they speak of this, an abstract of title being a collection of public documents, you had referred to something last session and even recently about if something were in a trust. Trust isn't a public document, so would that then not appear, or?
The ownership would appear.
The ownership
The
would appear.
trust itself does not appear, but there would be a certificate of trust that shows who the trustee is, what the rights are of the people who transfer it out of a trust to make sure that they had authority as trustees to do that, so, or a memorandum of trust could be filed. So those are documents that are public because in order to do an abstract of title, to follow the chain of title and all of the history of the ownership of that piece of property, all of the correct documents that need to be filed are filed, along with the deeds and other documents that can be filed as mortgage or whatever, so that whoever runs the title knows, as of today's date, what is the history and current ownership of that title.
And are there times when the deed is just for who owned it at the time, not the prior, but you'd want to know who the prior is because there might be some issues that are
let's just
uncovered?
suppose, for the sake of argument, that person who had the life estate sold it to me, and now I sell it to you, and now you want to sell it to another person. Without that chain of title, without that history, you might not discover that there's a defect in that title going to you or that person who's selling it now that needs to be discovered and either A, corrected, or B, disclosed so that you know what you're buying. So that history is very important too. And the history will also give you all those mortgages, and one of the biggest issues we've had over the last many years are all the transfers and assignments of mortgages and whether the discharge is appropriately recorded or not recorded. So many times we find an older mortgage that's not so old that it's automatically discharged by law but still exists, that we know somewhere along the way probably was paid, but we don't have the actual discharge on record, so that's something that needs to be obtained.
So the seller is supposed to provide a clear title. If I'm the buyer, I still want a title search done. That's something that's often claimed to be able to be something you could do online. Based on what you're saying, would you not advise that someone try to do their own title search?
You can do it, but I wouldn't rely on it. You're not a professional. You don't know exactly what you're looking for and what you might be missing. And more importantly, if you are buying the property with a loan from a bank, it's not going to be accepted by the bank anyway. They're going to require a title attorney who is also a title agent for an insurance company who can write insurance on the title. Because number one, you need to trust that the title search is correct, and number two, you need to guard against other defects. That's what the bank is going to be concerned about. That may not be disclosed in a title search. What might not be disclosed, you would ask? So I'll answer the question for you. What about adverse possession? So we talked about adverse possession before. That's not going to be disclosed in a title search. At a closing, you'll also see these survey exception deletions and affidavits that are signed, but there might be an issue with that. There could be an unrecorded easement, an easement by prescription, they might call that, which is sort of like an easement obtained by adverse possession, and that type of same theory and situation. So you own the house that's next to the lake. The house next to you for years and years and years have always crossed back and forth from their house to the lake. Do they now have a right of passage to go back and forth? It's not going to be revealed in a title search, but it may or may not affect the value of the property, and so it needs insurance from the bank's perspective, and really the new owners should want that too, in case it affects the value of their property.
And I was going to follow up with that before you actually broached this.
Sorry about that.
That's fine, no. But with title insurance, in asking why it's needed, who's it's protecting? It's actually protecting that buyer as he's going forward for the unknowns, and you're saying that a bank, if there's a mortgage attached to it, they will demand it?
Right. So oftentimes at a closing, when there's a loan, they'll ask you, do you want the mortgage insurance protection or the owner protection, which is just the one insures the title for the bank and the amount of the loan. The other one insures the whole purchase price for you and any equity that you would have in the property above and beyond the bank loan. If there's a defect that causes massive problems with the value of the real estate.
So would a lawyer, prior to closing, demand to see that title insurance to make sure that everyone understands what's in it and that there aren't issues that are going to compound their problems later on with the easements or whatever else?
No, it doesn't.
It won't happen then?
No.
It'll
What
happen
happens is you go to the closing, you pay for the insurance, and they send you an insurance policy afterwards. You put it away and you hope to never have to see it again.
Interesting to see that the lawyers will review it, though? You will review it?
They'll tell you what is covered in it.
Fair enough.
And so the title attorney who's writing the insurance will tell you this is, and oftentimes it's more incumbent upon, it's incumbent upon them to explain why you should have it. But if you have any questions about what it covers, you should, because it's not hazard insurance or fire insurance or anything like that. It doesn't cover some natural disaster. It's only about the chain of title, the title being good and valid in you, and that there's no defects or claims that can go back over time. That's why title searches go back over time. In 40 years standard, there is one interesting title insurance story. How true it is or not, I don't know, but the title insurance, the title attorney ran it back in Louisiana to, I think it was 1723 or 1823, whichever was about the time of the Louisiana Purchase. So they took it back to that date, and the title company that was writing the insurance says, well, we actually need you to go back beyond that, beyond when the Louisiana Purchase happened and the property was purchased by the United States. So he said, I can run it through the Native Americans who lived there and, all of that, but it doesn't make any sense. So I think, tongue-in-cheek, he wrote a title search back to beginning of time.
Beginning of time.
Which really didn't exist. But the point is, it does have to go back a fairly significant period of time, 1823, Louisiana, not that far, in order to make sure that whatever defects were existing before that won't come back and affect the value of the property or the title.
Okay. I want to talk about the easements and things, but surveying the land, surveying the property that you're about to buy or have sold, who has it surveyed? who, or do both parties need to survey it? Who's responsible for it? What about the agents involved?
Yeah, so give me more facts.
So if there are
Because I'll tell you this.
stones, for example, that were marking properties
right.
years ago.
But for the most part, when someone buys a piece of property, they don't do a survey.
They don't.
They don't. They go out, they walk the property, they look at the property. Is it advisable, or might you think about doing it? You might, but it's usually something that people don't do on a purchase of property, unless we're talking about commercial real estate, farm maybe, whatever. But for residential real estate, they don't usually do that, and that's why at the closing, there's that survey deletion exemption that the title attorney will require the parties to both sign, which is that there's no boundary disputes that you know about and all of those other things that go into that document. So is it advisable? Yeah, it could be, but it depends. If it's pretty clear by walking the property what you're buying, and at a closing, there's a plot and lot map that an attorney will have the parties' initials so that they're both on board that what you're buying is actually the lot and plat that's listed. Oh, I thought I was buying the one across the street. No, it's this one. They do that, but it doesn't really, it's not a survey. So it doesn't say, is it correct? Is it laid out correctly? It just gives you a ballpark idea of what you're buying and where it is.
Good to know. We touched on easements. What are they, and what should the buyer be aware of or concerned about if there are some?
So an easement is a right of somebody else to certain access or use of your property or the property you're buying. For example, you could have a piece of property that might be somewhat landlocked. So there's an easement of the right to pass and repasses, they say in the easement, to go from the street to your property through somebody else's property. So the easement is on that other property. It's called the burdened property, and the advantaged property, or the property that gets the use of it's the one in the back. So if you're buying the burdened property, the property that the easement runs through, you want to know about that easement for the right to pass and repass. And you may see it when you go out there because there might be a paved or unpaved path or driveway, but you need to know that because it affects your ability to do certain things with the property because you have to maintain that right for those people to pass there. You see it for utilities often. A utility easement running through the back of your property for the gas company to maintain its pipes that run through the back of your property, or the electric company to maintain its wires. It's a burden on your property, so it may affect the value of the property, and you need to know about those easements.
Other terminology than what you used, dominant and
Servient,
servient.
yeah,
The
same thing.
burdened property
Right.
is the
Servient property.
servient property, just
Right.
in case someone happens to run across
Well,
that.
you're correct. Those are the words that are more widely used, so we ought to use those words and not confuse anybody.
Okay, and what about future use? When you're talking about an easement, that's something that happened 2 owners ago, but do I need to know, and how do I find out whether or not there is future use planned for that parcel right next to me and a big box store is going up there? Do I have any guarantee about that, and how would I find out
Yeah.
about that?
Future use as opposed to an easement on your property, something
Yes,
different.
so easements already happened, I want to know about it, I make an informed
Right.
decision about
Yep.
whether or not I want somebody traipsing across my property, or if that's going to bother
Right,
me, if
which
I'm going to, now
that-
going forward.
Usually, like the title itself, the easement would be recorded, you can find it, unless it's an easement by prescription, as we talked about before, which is sort of like adverse possession. So that's how you find most of your easements. But future use of what your neighbors are going to use their property for, or you bought a piece of property that has 22 acres next to it, yeah, you want to know what those 22 acres are and what they can and cannot be used for. So if it's next to a conservancy, purchase that's restricted, yeah, that helps know that your property is going to be private and protected. But if it's just property, zoned for residences or commercial or whatever, you need to know that someone might be building a house next to you. And do you want that, and what are the rules, and what are the set-offs, and what are the lot requirements and lot size requirements? Those are things you want to know. And if you ask the seller if they know, and they know, they should disclose what's next to you, but it's up to you to find out for sure.
And to carry that point a little bit further, David, it may not be the seller's agent who knows, it may not be a buyer's agent who knows, it might not be the lawyer's responsibility to go seek that out, but the onus would then be on the buyer perhaps to canvass the neighborhood and ask a few of the neighbors what's up.
Absolutely, yeah. So
Zoning board too, right?
you could do that. You could check the zoning. You could ask in the town, the zoning officer, if they know anything about that lot, the building inspector, whatever it is in that particular city or town, to find out information. You want to get as much information as you can before you buy something. For the most part, you're talking about real estate probably in areas where it's already developed, so you know what's there. But if there's an empty lot, if there's some reason for you to be on notice that something could change, you want to find out what the possibilities are and what the likelihoods are. And, you know, if you're buying a piece of property with an empty lot next to it, you have to assume, if it's in a residential area, that that lot could be developed and built on. So just know that going in when you buy it, but you need to find that out.
How about if it happened to be a brownfield, a dumping area 20 years ago, 30 years ago? You might want to find that. I don't know how you'd find that. How do you find that out, David?
In commercial real estate, when you buy a commercial piece of property that could have been a waste area or something before, the bank, again, when you're going for a mortgage, will require you to get an environmental survey. So there's different phases or levels. The first phase might just be a search or a research. A second phase or a more involved phase might be some drilling. So there are requirements, especially when banks are lending money on those things with commercial property, to do that. Residential, maybe not so much, but we know in East Providence, for example, there are some areas where there's some development going on where there might have been some questions about that. So you do need to find out and ask the questions and do the research, you know, whether it's at City Hall or from the developer or whatever, the broker. You need to find out as much information as you can about what was there and what is it being developed and what remediation has been done, and as I say, as much information as you can get.
So clearly the onus is on you to do that.
Always.
So in that transaction that's pending, if there's a purchase contingent upon the availability of financing or on the sale of the house where the buyer is waiting to move out and buy something else, how does that get built into a purchase and sale agreement or staved off until one happens? How does that play out, David?
So you need to put all that information into a purchase and sales agreement because, again, we're talking about a contract, and it's the contract for the purchase of real estate, which is under the statute of frauds, which is a type of document that needs to be in writing. So all the information that goes into that contract needs to be in writing. So if one of the issues as the buyer you have is, my purchase of this property is contingent upon my selling my house, put it in. If it's contingent upon a mortgage, put in the terms of the mortgage that it's contingent upon. Is it a 30-year conventional mortgage at prevailing rates? Put it in. Is it a special mortgage, you know, more than conventional mortgage, usually 80% max. If it's more than that, put it in. But put in what terms are conditions that are conditions precedent, as we call it, to your buying the property, so that if those conditions aren't met, you have a refund of your deposit and the contract is canceled.
Okay, and if you are thinking about buying a property, but you absolutely don't have the money to do a deposit or make a substantial deposit, the 20% that some banks require, even first-time home owners may get away with a zero deposit and X number of points at closing. If someone wants to do lease to own, rent to own, lease option to buy, rent to own, go through those options a bit and where the problems arise.
Well, there are problems for both the seller and the buyer.
Yes.
And so those types of arrangements can be entered into, and they're very helpful, especially for a first-time buyer to build up some equity in it. So from the seller's point of view, I have a piece of property, I haven't been able to sell it, I've got someone who's interested, they're going to need me to work with them to some degree, so you might rent it to them. And in the agreement that you enter into, you might say that each month's rent can be considered towards, as a deposit towards the purchase of the property. But if I'm the seller, I want that to be clear that if you don't buy the property, you're not getting the money back. That was rent.
So did it need to be rent plus an additional amount that might go toward the deposit, a portion of it toward a deposit? Do you need to change the structure of that?
All subject to negotiation. So,
Who would do the negotiation, a real estate
well,
agent?
it depends. If
a
there's one
lawyer?
involved, a lawyer can be involved in drafting it, but the negotiation between the buyer and the seller, if they have agents, then between the agents.
Yes.
But it's, from your perspective, because you're the buyer, I'm the seller, from your perspective, you want to be able to get as much of it back as you can. From my perspective, I'm renting it to you, it's all rent to me, but I'm going to give you credit for some, none, or all, depending on the deal that we make for the eventual purchase price and everything, as to how much of your rent I'm going to credit as towards the purchase. So, and I've seen this work out in a number of different ways. I've seen where the buyer is ready to buy, but the seller has a title defect that they have to clear, but they want to move quicker, so the buyer wants to be in, but the seller's not ready to close because there's a title defect. In the case I remember, there was actually litigation over a claim. The person who owned the property died. There was litigation as to who owned the property, or whether there was a promise made from the estate owned it, and somebody said, well, they promised me money, and so they've got a lien on the property. So the seller had to wait for that lawsuit to be resolved before they were free and clear to sell it. So the buyer, who was ready, willing, and able to buy, said, I don't need to rent your property, but if you want me to buy your property, then everything I'm paying is towards the purchase price.
And that kind of negotiation, is that something that usually a buyer-seller arrangement could be worked out easily enough, or is that something that really requires a lawyer's intervention to make sure that it stays reasonable, fair, and legal?
It depends. It depends on the parties.
Okay.
And so if they're able, you know, and sophisticated enough to be able to protect their own rights and do that, they can do that. But I do believe eventually a lawyer's going to have to be involved to write it up in a way that carries out what they said they wanted to do.
Good to know. We hope that this has been helpful to you. There are so many more frequently asked questions that we didn't have a chance to cover, but we hope that this keeps you a little bit better informed and out of trouble. Thank you for tuning in to The Law Matters, because of course the law matters to you.